Last week, Britain's financial regulator fined JP Morgan a record $49 million for commingling client accounts. Lawyers are calling the move a wake-up call to senior managers at other firms. Here to explain is Ellie Raisin, editor-in-chief of Westlaw Business Current. So, Ellie, in this case, no clients were directly harmed by what one lawyer called JP Morgan's administrative oversight. So, what's the big deal? Why does commingling these assets deserve such a crackdown?
So, it's a very interesting issue because we all take for granted that the plumbing of the banking system just works and it's there and it functions. And if you think about it, our buying of our houses, our storing of our personal accounts, and also big deals which have large escrow amounts or money flowing back and forth among, for example, M&A parties, they all rely on this really working efficiently. And in this case, what happened with JP Morgan is basically the regulators called them on it and said, no, you can't mix monies together. And the reason is shown to us by Lehman and certain other cases that have come about. When a Lehman goes down, if all those monies are commingled, it's really unclear who gets first dibs on those funds, and depositors end up sort of bottom of that bankruptcy pile. And so what the regulators are basically saying here is keep clean books and records, keep it all separate. Why? Because they should be separate, and in the extreme case of a Lehman, they absolutely have to be separate or people lose.
What's the upside for the banks of commingling them?
Well, it depends on what kind of bank you're talking about. Some banks, it may just be sort of saving on the administrative overhead, which is why that one lawyer called it simply an administrative oversight. There are other banks that have done somewhat more dubious things. There is one particular lawsuit that has been wending its way through the US courts relating to a bankrupt company called Land America. And in Land America's case, they intentionally commingled escrow funds that had to do with people's house closings. And they took all these monies and they piled them together, and they were able basically through a Ponzi scheme-like structure to pay people out, and they needed to commingle funds to keep paying. And when the music stopped, they were stuck. And in that case, not only were they stuck, but their bank, as the deep-pocketed body behind them, was also attempted to be gone after by plaintiffs who said, well, Land America's out of business, but SunTrust, you're not, and we're coming after you.
So your analysis raises the question of banks and doing this as co-conspirators. So what do you guys mean by that, and how can senior executives protect themselves in these cases?
So in the extreme, they do get labeled as co-conspirators, and that's exactly what senior executives at banks want to avoid, because for the most part, nobody here is doing anything intentionally wrong. And the way that banks can protect themselves is by having the right policies and procedures in place. But they need to understand that this is not a laughing matter, and $49 million shows the banks that the regulators are no longer basically ignoring the issue. They're very aware of the risks to the many institutional clients out there, as well as, of course, consumer clients.
Now, this fine against JP Morgan was across the pond. What's happening here in the U.S. in terms of regulatory action or in terms of the courts? Is this just the tip of the iceberg?
So it's tip of the iceberg, it's beginning or middle of the process, but this is not just a UK issue. It absolutely is a US issue. The Land America SunTrust case that I mentioned a few moments ago is a US case. But there are others that predate it. Wachovia, for example, was gone after also for much the same reason, where one of their clients had commingled funds and they were deemed to be essentially a co-conspirator, not by a court, but that was the accusation, and before they had a chance to go to court, they basically settled and paid a whole lot of money out. And so essentially this is very much a US issue. US regulators have stepped into the fold as well. For example, in Virginia, where the Land America situation played out, Virginia civil and criminal authorities are getting together now to pursue financial fraud. And just today it was announced that in New York that as well is happening. The FBI is looking to band together with others in order to use some techniques that have been developed for terrorism chasing, no less, in order to go after these sorts of financial frauds.
All right, Ellie Raisin, I know you'll stay on top of this story for us. He's editor-in-chief of Westlaw Business Currents. I'm Jen Rogers. This is Reuters.